Ladies and gentlemen, as I mentioned to you, what you don't know is that the courts of the United States and most of the courts of the world are courts of presumptions. Everything a prosecutor says is a presumption. There are no facts. Go ahead. I literally told a judge, oh, I plead guilty to the facts, but innocent to the charges. Simply, I told him that out loud. Out loud, I told him, because I knew there were no facts. I had not done anything to be guilty of. So I'll plead guilty to the facts. I'll submit to the jurisdiction under the facts. And he said, Marcos Lopez, he's now a federal judge. He was a magistrate at the time. This idiot, and he's still an idiot to me, he said, oh, well, if you're going to prove guilty, we can just move to the sentencing stage. Oh, no, I said to the facts. And he immediately stopped and said, well, I'm going to find you not guilty and hold you over for trial. Excuse me? I just pled guilty to the facts. What you mean? I didn't say that to him because that's when I tested their so-called system to prove these things to everyone else. I allowed all of that junk to happen so that I could prove to you guys what the courts were really about. I learned about presumption way back in 1994. 1984. What's me 94? When I was 16 years old. Because at that time I started studying the courts. And I came across this thing called presumption of law. And when I read it, I'm like, what? And I literally said that out loud to myself while I'm in the library. And you're not supposed to be talking out loud in the library. And I go, what? This don't make no sense. And as a 16-year-old, I'm the same person. I'm like, shut up. But never mind. It didn't make any sense that an assumption could be held as factual, and if I don't overcome their assumption, they win. Ladies and gentlemen, lawyers go to college. They go to law school to learn how to argue presumptions. That's why they argue, because they're debating, and whoever wins the debate, whoever persuades the judge that my argument was better than his, Your Honor, they win. It has nothing to do with the facts and who's right and who's wrong, who proved their case, who didn't prove their case. That's why pay attention. Beyond a reasonable doubt. There is no such thing as beyond a reasonable doubt. You must object to that beyond a reasonable doubt standard. It's a standard. It is not the law. The law says they have to prove your guilt. It's not a beyond a reasonable doubt. You see, they did the beyond a reasonable doubt junk when they, pay attention, went administrative. But that's not what this video is about. This video is about where you all are using your GPT models and you want to do conversations about facts and conclusions of the law, what is and what is not, and rebutting presumptions of the court. I want you to pay attention. This is a prompt. This prompt, and this is DeepSeek. This is the beginning of the conversation. There's nothing else up here. There's a new conversation. Matter of fact, to prove it to you, gotta click in here for a second. Where's the mouse? There you go. And undo that. See, new conversation, now redo. Okay? So new conversation, I'm gonna hit enter. It's just a prompt. I just created this prompt this morning, less than 5 minutes ago. See, it's only 4 minutes the video started. It's when I created the prompt that I said, hey, let me go ahead and put this prompt out there for these people so that when they're using their GPTs, including anyone that I've created, go ahead and use this prompt. It won't violate any of the protocols of any of your GPT models that you're using, whether it be Poe, Kame, or DeepSeek, or Claude, or Gork, or any of them, Grok, whatever you want to call that stupid, man, that's a dumb name. Anywho, it really is a dumb name. Or using ChatGPT, or Claude, or Copilot, it doesn't matter. Whichever one you use, just put this in there. Now notice this is the response. I have assumed the position as requested. the presumption killer. I am operating under an analytical framework of the presumption killer. Operating protocol acknowledged. From this point forward, in this interaction, I will adhere to the following directive. I will document any identified presumption. I will explain why the identified element is a presumption, and I will provide a rebuttal based on facts and conclusions of law. My core analytical principle is that a presumption is an assumption that substitutes for proof of material fact. Due process requires proof of facts and not an acceptance of an assumption. See, presumption of law violates due process. And that's what the prompt tells you, because it's actually a conversation. I will put it in the GPT so that you'll have it. My function is to identify where assumptions is being used in place of factual evidence and legal conclusion. Now I'm ready to proceed. Please present the material, the statement, the statute, the regulation, or claim you wish me to analyze. Ta-da! I told you that you all don't understand, but I want you to understand. I told them to leave me alone. I told them if they didn't leave me alone, that I would make sure they understood who I am. So, ladies and gentlemen, this is my showing them who I am. You see, now everybody will be challenging their presumptions, and wait till you get to the Supreme Court cases where the Supreme Court has said presumptions are unconstitutional, they violate due process. The Supreme Court has said it, so why have they sat back and allowed these courts to continue to rely on presumptions? Because your attorneys don't highlight it. So now you need to highlight it by simply responding with your presumption killer communications. Create your petitions based on killing their presumptions, and then state your facts and your conclusions of law. And ta-da! Now, I forgot to do one thing, so this is what you're going to have to do. Wake up. If you provide a response, you will have to do so utilizing either the legislative enactment and not the revised statute and or the codification of the legislative enactment, evidence of law is a presumption. The law is the law. Exclamation mark. Under the Constitution, there is no such thing as evidence of law. There is only, open quote, the law, close quote. Exclamation mark. If it is a state constitution, it is still the law enacted by the legislature. It's known as the legislative process. So if you utilize a code at any time within this conversation, you must also include the original enactment of Congress. Exclamation mark. And remember, you must always provide an irrefutable rebuttal to the presumption. Exclamation mark. Stop listening. Okay, ladies and gentlemen, what I'm doing is I'm adding that section to this. You see, it's not a long conversation. Copy. It's not a long conversation. And now it's going to tell me that it will use actual law. See, the problem is most of you are using U.S. code. Okay, fine. You didn't want to listen to me that U.S. code is not the law. So to do you one better, from now on, use this prompt where it will give you the U.S. code and the statute at large. See, the presumption is identified. A presumption is that the published code, blah, 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 is in itself the law. This presumes that the codification process is a perfect, authoritative, and conclusive statement of the legislative will, requiring no reference back to the session laws or the enrolled act. Why this presumption? This is a presumption. It assumes the factual conclusion that the code is a definitive law. You can now challenge the stupid code. You can rely on the statute. If they charge you with the code, Lord have mercy, and they don't list the statute at large that they relied upon or the original assembly bill passed by the state legislature, then you can kill the entire case and it is dismissed with prejudice because they can't recharge you with it thereafter, nor can they amend the indictment or amend the charges. Ladies and gentlemen, they can't do that. They can't amend the charges. They can't do a do-over. You must understand all of that stuff is a violation of due process. If you don't believe me, put the prompt in and ask the questions. All right, we're not going past 12 minutes on this video. I just wanted to sit down and explain this really quickly. I have 2 appeals. I just finished 1 appeal. I have the other appeal, which is 72 pages long at this time, because that's how many presumptions are in the case. Because the judge ignored everything in the appeal brief. Because this is what they do with all of you. They ignored everything in the appeal brief. They only focus on what the judge and the other party said. They did not focus on anything of what the actual so-called debtor said. This is a bankruptcy appeal. Well, you can't do that. That's denial of the due process. A denial of due process. Okay? Didn't address any of the concerns of the debtor who was filing the appeal. And so now we get to attack the judge. Because the judge didn't provide any facts and conclusions of law, neither did the bankruptcy court or the trustee or the attorney. Everybody just made accusations. I don't have time for rebutting their accusations. No, this is what we're bringing. We brought the case in the first place. We don't have to rebut your junk. You have to bring forth evidence and proof to the contrary of what we brought. This is a controversy. This is not an argument. Pay attention. Courts are there to handle controversies, not arguments. All right, have a good day. I said 12 and we're now 12:30. Bye-bye.